Everybody, I'm Holly Smith with GMA. Welcome to our Teach Me Tuesday webinar, considering COVID-19 alongside ongoing workplace regulations. This is a part of a series of virtual trainings and programming we're offering over the next several weeks. Please visit our website at mygma.org for information and to register for upcoming programs. Just a few housekeeping notes for today. If you have a question, please type it into the questions pane. We will address questions aloud throughout the program and at the end. There will be a few polls during the session. To vote, just click on the answer that best applies to you and click Submit. Only the aggregate results will be shared with the audience. We are recording today's session, and the replay will be posted on the Member News and Resources section of mygma.org. Today we have with us Beth Langley, a partner at Brooks Pierce in Greensboro. She has over 25 years experience counseling employers of all sizes in employment law issues, including workplace employment compliance, executive compensation, employment agreements, discrimination and harassment issues, and trade secret protection. She also represents clients in all levels of state and federal courts and is a DRC certified mediator. Beth is a fellow of both the Litigation Council of America and the American Bar Association. She has been regularly honored by the leading legal ranking publications such as the Best Lawyers in America and North Carolina Super Lawyers, and was recognized as an outstanding woman in business by the Triad Business Journal in 2017. Beth received both her bachelor's and her law degree from Wake Forest University. When she is not in the office working for clients, Beth is serving as a member of the NC Bar Association Board of Governors and is a member of the United Way of Greater Greensboro Human Resources Committee. Before we turn it over to Beth, GMA has a door prize we would like to present. And our winner is Cindy Knoll of Children's Home Society. Cindy, I think I see you on. If you would send me an email with your address, we can mail you your prize. You've today won a $25 cash gift card. So thank you for being here. Beth, I'll turn it over to you.
Great. Thank you so much, Holly. And I really appreciate being here with all of you today. There's just so much going on in our world, and especially with this pandemic, and I appreciate the opportunity from GMA to talk with all of you. My background in growing up is with a small business, and so that's always with where my heart is and where I always kind of where my perspective is from. So thank you so much for this opportunity. Just a few ground rules and some some background information as we start today. Amy, if you'll go to the next slide. The information here, we're not trying to give you legal information or create an attorney-client privilege. We also, when you ask your questions, if you'll not place any of your company's particular information in there, kind of keep things in a hypothetical, because we want to make sure you maintain your confidentiality as well. As far as sort of housekeeping items, Holly went over some of those. There's a method for you to ask your questions through this WebEx, so please be sure to do that. We'll also have like some natural breaks for you to do that as well, and as Holly said, we'll have some polls. Today's topic, what I really want to focus on is kind of what is the current state of the employment laws and the regulations going on with COVID-19. We're at a really key point today. Here we are, Tuesday, the 28th of July, and the Guilford County schools are going to meet today and decide about school reopenings. Forsyth has already decided. Things are really in flux. We're a couple weeks before the, actually 1 week before freshmen start at some of the colleges. So what's happening? This is a key time. What are your business's obligations if you had temporary layoff notices early on in this pandemic, and now you're thinking some of those may be permanent? And then how can you avoid litigation? That's always top of mind with every organization, whether it's related to terminations and layoffs, or whether it's related to safety issues. So those are going to be the topics for today. There's a lot out there. I'm not going to represent that I can cover every single thing, so this is going to be a top level view. Feel free to follow up with me if you have any questions going forward, and I'll be glad to address those. Next slide. So one thing I do want to point out to you, our firm, Brooks Pierce, has tried to put out a lot of comprehensive COVID-related issues. Feel free to go there as a continuing resource. I'm not saying that for marketing purposes. Sorry, Amy, our marketing manager, but we are truly trying to keep information updated for you. First issue or legal statute I want to talk about is the Families First Coronavirus Act. I'm sure you all have heard about it, but I want to talk about it in context of where we are right now in this last week of June. The FFCRA, as we're calling it, was enacted in March by Congress. It was one of the first relief packages that was placed out there for primarily employees, and it has two components: a paid sick leave for up to 80 hours and an extended family medical leave. And this statute is applicable to employers with 500 employees or less. The key things I want to focus on is employees are looking at this FFCRA with renewed interest right now when we're looking at school reopenings and a lot of schools choosing a virtual option in August. So go ahead and be planning for what you're going to do if you have a lot of employees, if you're in that 500 and less category of how to make plans for employees who are going to be asking for this FFCRA leave. There's this virtual school that's going to fit within reason 5 of the FFCRA. So that is under the EPSLA, that paid sick leave, or the extended FMLA. There's up to 12 weeks total here of some combination of paid leave, and it comes in that reason 5 for school closure. So virtual school would fit within the school closure because the school building will not be open. That the maximum pay for that reason is $200 a day to the employee. That's the maximum amount. Now, if you were a recipient of a PPP loan, you may not be eligible for the tax credit reimbursement for that. That's something you need to talk with your attorney or your accountant about. You can either apply for the PPP loan forgiveness, or if you seek either that tax credit, that's going to be counted against your loan forgiveness. So that's something that you need to be aware of. But go ahead and start planning, because the downside to not, employees will be eligible, and denying employees this leave, which they're entitled to, could subject you to some liability, and the liability is pretty steep. It's the same as if you had a retaliation claim under FMLA. The next slide, please. So what about remote work? If an employee asks, can I, instead of taking this FFCRA, can I do remote work, or vice versa? Can the employer affirmatively say, well, we have remote work, so you don't need to take this leave? That's something to keep in mind. I really encourage you to go to the U.S. Department of Labor website. They have a very thorough FAQ on this FFCRA leave, and they talk a lot about remote work. An employer can offer remote work, but one of the key questions is, can the employee actually perform that remote work, the remote work duties, and still take care of their kids, and handle those virtual school obligations. So that's one of those things to take a look at. The Department of Labor really encourages employers and employees to have a lot of conversation about this. Flex time is highly encouraged. So maybe you could work out an option where employees are working, earlier in the day and split their work day, and again, maybe later in the afternoon, and some of that time in the middle is where they're taking care of the virtual school obligations. A lot of it's going to depend on the ages of the children. So that's one thing to look at. They're also encouraging intermittent leave. Employees can, intermittent leave is not an option for those first 2 weeks of the paid sick leave, the 80 hours, but it definitely is an option for the extended FMLA. Another thing to keep in mind is how to handle PTO or vacation leave. There's some statutory requirements on that, and also now regulations. Employers cannot require employees to take that intermittent leave, take PTO or vacation leave concurrent with the paid sick leave, that first 80 hours. They can, though, require the PTO and vacation to run concurrent with that extended FMLA leave. And that's more, when you kind of think about how FMLA works regularly, that's how that extended FMLA works. So let's have just a quick poll. And this one has to do with kind of what you all are seeing out there. So have your employees requested FFCRA leave due to the recent announcements of some of our school districts of virtual school reopening or daycare closures? And just some simple options: yes, no, not yet, but we're making plans.
We're going to give you guys just a few more seconds to vote. If you're having any trouble voting, what you do is you just click on your answer choice and then click submit.
And maybe for some of y'all might be early since Guilford County is voting tonight, but I know we have some folks who border up to Forsyth County and close to Kernersville, so you may be getting some of those requests. Well, that's really good to see that 2/3 of you are making plans, because these requests are going to start coming. This is pretty much inevitable from what we're hearing from both businesses, school leaders. The one thing we know, one constant that we've had is change, and there's going to be a lot of change. So planning is your best resource. Just some other highlights on this FFCRA before we move to another topic. Don't forget about that federal poster for the notice of rights of the FFCRA. Since a lot of us are still working remotely, it's kind of easy to forget about little housekeeping items like posters. So what the U.S. Department of Labor has done is make a virtual poster that you can send out to all of your employees. I've included a link here on this PowerPoint, so I'm sure when Holly posts all this out here, you can get this. You can also go to the United States Department of Labor website, and you can find that link there. For the FFCRA tax credit, for those of you who are going to seek that tax credit, DOL has new forms available for the FFCRA. So check out the DOL website to get the updated forms. And again, as I've already explained, there's no tax credit available for those PPP recipients who are going to seek full loan forgiveness. It's one or the other. There's not a so-called double dipping available for that. All right, well, good deal. Kind of moving along, I'm just kind of checking I think I skipped over one poll. So let's go to the, Holly, if you wouldn't mind, that first poll that we had talked about. How often do you review executive orders or the CDC, the Osha and Eeoc guidelines? One of the things that I personally have experienced is just the vast amount of information that we are having to absorb on an almost daily basis of new statutes, regulations, guidelines that are coming out. And it's so much to both learn, digest, and then implement. I truly cannot remember a time in my career when there had been where there's been this amount of changes that have had to be implemented in such a short amount of time. So it's interesting that a lot of you are relying on alerts and, you know, GMA, law firms, and those sort of things. It's a really good resource. One of the things that I think all of us are finding is that even going back to the source information like CDC and Osha and GMA, it's almost information overload. Not GMA, Osha and the Eeoc. It's so much information to consume. We even have staff here who are monitoring all that information on a daily basis. So kind of starting with like the EEOC started sending out updated guidance back in March on pandemic response. And they've been pretty diligent about updating that. And I know many of you are very familiar with the regular ADA guidance. The EEOC's recommendation and guidance on pandemic response is so different from what we're used to as far as dealing with medical issues in the ADA context. So, we've had to sort of get up to speed on what we can and cannot do. So one of the key factors in thinking about the do's and don'ts, how you handle medical information and dialogue with employees, yet keep your workplace safe, has been compliance with the Americans with Disabilities Act. If you've not done so, I really do recommend that you take a look at the EEOC guidance directly. Maybe not just, it may be one of those exceptions to just relying on somebody else's summary. This website provides really key information on what employers can and cannot do and should be doing during this pandemic. Next slide, please. The key
Beth, I have a couple of questions, if I can break in for a moment. First was about the FFCRA leave. If a company has fewer than 50 employees, do they still have to provide the leave if they can't afford a lot of their employees being out of work at the same time?
Holly, that is a great question. The FFCRA has the presumption that it applies to all employers, 500 and below. There is a manner in which a small employer, 50 and under can make a showing that the requirement should not apply to them, and it's pretty steep, to tell you the truth. First of all, it's not an opt-out. It's you have to make a financial showing, and the standard has actually been set by the American Association of Certified CPAs. I probably got that wrong, but it is the CPA organization, and it's pretty much saying that by complying, this will put me out of business. And that's the high bar that has been set. It's also a moving target. So it's not the, you don't just have to look at that, do that analysis with the first employee and then it's done. It could be that, all right, I have to make this analysis at the first request, the second request, and the 10th request. So, for instance, if this company with 50 employees gets 30 requests, it's not going to have the resources to continue to operate. It may not be just a financial situation. It may be a pure practical situation that there are not enough bodies to be able to continue the work. So it is a fluid analysis, but that FAQ that I referred to, there's a FAQ for employers, and it sets out very specifically what the requirements are, and the employer just has to meet that standard at the time. There is not an application to the DOL. It is just that's what the standard is, so that if the employer denies the request and the employee files a claim, that employer has to have all that documentation, financial and operational, to show, if there's a DOL audit or if there's a lawsuit. I apologize for the long answer, but it's a long answer.
Oh, and Beth, this is along the same lines. Is there an exception for essential businesses?
There is not an exception for so-called essential business. There are exceptions for healthcare workers, but there's not a true exception for, all of the businesses that got to remain open and were designated essential businesses by the governor.
Thank you.
Those are great questions. Thanks. With the Americans with Disabilities Act, what EEOC has told us, there's things that we can do as employers and there's things that we can't do. Like we can screen for temperatures. There's some practical implications to that, like how do you do it? How do you do that safely? I have one client who has actually purchased a several $100 machine that employees step into upon entry, and it takes their temperature so that no one has to get close to the employees to do that process. And it's allowed. But then you also have to make sure that from a medical confidentiality standpoint, that that's not like displayed up really broadly, and that the temperature is maintained in a confidential way and all of that. Antibody tests are not allowed. That you may recall that started sometime in early June, and the EEOC shut that down pretty quickly because that, from their perspective, was a violation of the Genetic Information Act. EEOC does allow and encourage, along with CDC guidelines, notification of to health departments if an employee tests positive, but there's a lot of constraints on what you can do with that information. Of course, you cannot just send out a broadcast that says, hey, Sue tested positive. You can have limited information that says an employee in our area tested positive, or employee in our work site tested positive, and you can notify individuals who work near that person who tested positive, but you still can't reveal the name of the individual. You cannot screen out individuals who you believe to be high risk and tell them not to come to work. A lot of that was going on very early on. You can't do that. That violates the ADA. Employees can screen themselves out. Employers cannot screen them out. That's a big distinction. And when remote work is available, and that's a reasonable accommodation, employers are encouraged to make that reasonable accommodation. That's always a case-by-case situation, just as it always is with the ADA. So one thing to keep in mind is that with remote work, if that's a temporary situation, make clear to the employees this is a temporary work situation, and this is long term. This job is a on-site position, so that you're not somehow by accident converting that job to a remote work job. Make sure that you're clear if you intend for this job and it needs to be performed at your physical location, that you're retaining that those essential functions need to be performed on site, and we're just doing this temporarily because of this pandemic. Another key issue that comes up frequently that the EEOC addressed really squarely head on is that there is not a requirement under the ADA to make an accommodation because an employee's family member or someone in their home is high risk. An employer can certainly make that accommodation, but it's not required under the ADA. So one poll that I thought would be interesting is to find out, are companies out there taking temperatures? There are lots of different ways to go about that, whether employees are doing their own screening, whether companies are doing it on site, and it certainly depends upon the nature of the job. So thought it would be interesting to see what you all are doing about that. One of the, while we're waiting for the vote, I'll tell you kind of one of the war stories that we had early on. We had a situation where clients, excuse me, were taking temperatures, but then they were kind of broadcasting that temperature around, like so-and-so is 98.6, so-and-so is like they were assigning the temperature number to the employee, and we're like, no, you can't do that, it's confidential. Temperatures are confidential medical information, so make sure that you're keeping that information confidential. So it looks like we do have a substantial number who are taking temperatures in one form or another. Having employees certify, about 20%, who are actually manually taking temperatures, who are considering doing it in some form or fashion. Another question that we had is if you have had any employees request remote work because they have a family member who is at high risk. I wonder if any of you have had that issue come up in your workplace. we now know that the EEOC is saying that the ADA doesn't require that, but employees have, spouses or children, or maybe even just roommates or significant others who may be at higher risk. And it's just interesting to know how employees are handling that from a human relations standpoint rather than just a legal point of view. One interesting thing about this whole pandemic is that we're really learning as we go along, and many companies are making a lot of accommodations that are not required, but they definitely want employees to feel safe. So no one has had that request. It's interesting. We've seen it in some circumstances, and especially early on when there's a lot of remote work going on. So that's sort of interesting. This is a nice little segue into Osha. So many of what the EEOC's guidance is stating, you're going to see with Osha. I'll say that the federal agencies have done a pretty good job of coordinating together, including with the CDC, to have a unified response. Despite the fact that it changes a lot, they've at least been pretty unified in not having conflicting requirements. So I think Osha is one of these examples. So Osha's general duty clause is to provide a safe workplace to all employees. I say employers here, but employers have to provide a safe workplace. And that's just that general duty clause that we've all known. And so when this pandemic hit, even before they named it a pandemic, Osha had a blood-borne pathogen specific requirement, but no one was really clear about, okay, is that what we're going to say applies to COVID-19, or is it something else? So pretty quickly, Osha started turning to the CDC for guidance on what should be employers' requirements for handling this. And then when COVID-19 was definitively named a pandemic, then most definitely Osha started turning over to CDC. CDC has really become the standard for the general duty clause as to COVID-19. Now, one thing I do want to caution you about is all of OSHA's other sort of requirements are still right there. You've still got to comply with Osha. And more particularly, be aware of Osha's whistleblower protections. My thought is, going forward, this is the area for the largest amount of potential liability for employers, is employees expressing concern about safety, one way or the other, and then sometime shortly after that, there is what we refer to in employment world as an adverse action. It could be a permanent layoff, termination, a poor performance evaluation, and that's going to be that presumption on the employee's perspective that it was because the employee raised a safety concern. And we're seeing a lot of safety concerns because employees are scared, but they don't know. This is new, and this, we don't know what to expect. The guidelines change frequently. The numbers spike sometimes as far as cases of COVID, and we get a lot of new information. So the best advice that I can give you on this, it's not legal advice, it's just from years of experience. So I don't have an attorney-client relationship with you, is take every safety concern that employees come to you with and show them how much you appreciate them raising it, explain all of the precautions you're taking, and then make sure that if there has to be some sort of disciplinary action or termination due to business downturn, that you've fully documented exactly why that took place. You don't have to go back and reference that safety concern, but just make sure that you can explain why that happened on its own, and you've got really good documentation for it, because I really think that's the biggest exposure for employers in the near term. In the near term, I'm meaning the next 6 months, the next 12 months. I think that we're already seeing some of this, and I think we're going to see more. I think that's where the plaintiffs' lawyers are going to line up. Okay, next slide. So this is where we see the retaliation claims, and they're in different places. I've talked about OSHA, the FMLA, which is sort of an extension to that FFCRA, the extended FMLA, the ADA. All of these federal statutes and some state statutes have retaliation provisions, and these retaliation claims are so much easier to prove than some underlying discrimination or that or an underlying wage and hour claim, or that there was a safety violation. Just the fact that somebody raised the concern puts them in a protective bubble. So just be really aware of these things. For ADA, if somebody claims that they've got an underlying condition and they don't, they're at higher risk, make sure you engage in that interactive process with them, and have a really careful manner in which you proceed. So I truly think this is going to be those retaliation claims are always, but now, the heightened risk for employers. So this sort of takes us to the next kind of issue. I was thinking at first we were like 4 months out, but we are really 5 months out from where when I start thinking about where, as a lawyer advising clients, we were getting COVID-19 questions in February, especially folks, companies that had international practice. Companies were really starting to see impact before March. And March is really when things really went south, especially in North Carolina, when you think about the governor's order that second week or so of March, where businesses, restaurants and such were shut down, and then we went to a stay-at-home order a couple weeks after that. So a lot of temporary layoffs happened in March, early April. And a lot of companies either sent out a warn notice with a temporary, saying that we're going to have a temporary layoff, or they didn't send a warn notice because they thought, okay, warn doesn't apply. So warn is a federal statute that requires any employer who is going to have an employment loss, so either a plant closing or a mass layoff of 50 or more employees at any location, that they have to provide notice to the State Department of Commerce Rapid Response Unit, to the highest ranking local elected official. So if you're in the city, it has to go to the mayor. If you're outside the city limits, it goes to the chair of the county commissioners. And you have to notify all affected employees. And whether or not you have an employment loss of 50 or more at any location, I will tell you, is a very detailed analysis. Whether you count, who gets counted, who's part-time, who's not part-time, all of that stuff, it's an intricate analysis. Short-term layoffs under the Warren statute are not considered short-term meaning less than 6 months, are not considered an employment loss. But if that layoff extends more than 6 months, then then you go back and start counting from the first day of the layoff. So, for instance, if you're a company that had an employment loss of more than 50 employees, say you're covered by WARN and you had a layoff, I'm going to make up a date, March 20th. And now we're looking, and you can see ahead and see, okay, oh my gosh, in September, this layoff is going to be permanent, because I don't know that we're going to get out of phase 2 or be in phase 3 early enough for me to bring all these employees back, and I'm still going to have probably 50 affected. WARN requires 60 days prior notice. There's some exceptions. And of course, no one is tested with the courts whether COVID-19 fits with those exceptions. We're thinking it may, we don't know. So, if you think you may fit within a permanent layoff of 50 or more, you really need to be working with your employment law counsel to figure out what you need to do to get those WARN notices out of the permanent layoff. The failure to provide that required notice it's really costly. It's 60 days wages and benefits for the affected employees. So it's really, really important. And this is a key time for employers to be looking at that, because we're right on the cusp of coming off of, we're about 4 months out of when a lot of those temporary layoffs happened. So we've got a small window if we're going to make that 60 days notice before that full 6 month layoff, 6 month time frame is crossed over. So it's really, really important to be looking at that issue if you think your company is going to be affected, and to have layoffs of 50 or more when that start date may have been, let's say, about 4 months ago. So be thinking about that. I cannot stress to you how important that is, to be looking at that issue if you think your company may be in that situation. Contact your employment law counsel. Go ahead and start working on those things as soon as you can.
Hey, Beth, we've got a couple questions.
Sure.
The first is, WARN only applies to employers with 100 plus employees. Is that correct?
That's correct.
Okay. And the other one is, what if
and I'll also say it's very fact specific on how you count the employees.
Okay. Another question is, what if an employee claims that he or she has a condition covered under ADA, but that person has never told you of this condition? Under HIPAA, what questions can the employer ask?
That's the second question. That's a really interesting question. So if the employee just says to you, I've got a condition where I'm at high risk, say, for COVID, HIPAA frankly doesn't apply. HIPAA really has to do more with health insurance information. What the ADA allows you to do is ask some specific information of the employee about what the condition is, what reasonable accommodations do you need to perform the essential functions of your job. And you can ask the employee for some documentation. The EEOC right now is cautioning against asking for too much medical documentation, because employees are having a hard time getting actual in-person, doctor's visits. However, you are allowed to ask the nature of the condition and get at least some documentation of that, and and what restrictions are required. What sometimes is referred to as HIPAA is actually confidential medical information that the ADA requires employers to keep in a separate medical file. So HIPAA it's important to think of it as highly confidential and to keep it that way. It has to be confidential and in a separate medical file. You cannot reach out to the employee's physician. Some employers have made that mistake. You cannot do that. I hope that answered the question on that. Okay. All right. All right, some additional workplace concerns. Make sure, or just considerations, not really concerns, but make sure that at whatever phase of reopening you are, and I know that there are various stages that we're all in right now. One, make sure you're consistent with OSHA guidelines. Make sure that you have a COVID-19 coordinator. What that means is that you have a designated person who is keeping up with the different OSHA and CDC guidelines and EEOC and DOL regulations to make sure that all of that is being handled in a centralized manner. So that way somebody is keeping track of all of the changes. There literally are changes every day. Make sure that there's somebody on point to be doing that. And that's actually consistent with OSHA guidelines, that there is somebody who is reviewing all those. There are industry specific guidelines. So, in addition to just the business reopening guidelines OSHA has, there are business specific guidelines, and those are also being updated. So make sure that somebody's on top of that, because like even last week we had a change from CDC on their recommendations on wait periods before someone who had been exposed could come back to work. So those are the type of things to be on top of, and just make sure that one, you have someone who's coordinating all that, and then make sure that you've got those your requirements posted and being pushed out to your employees for two reasons. One, they know what the requirements are, and two, so they know that you're actually doing these things and taking it very seriously. On this fourth bullet, just be flexible with employees. I know it's frustrating. It's really frustrating that we've got disjointed workers, employees right now, some working remotely, some working, on site. It's just sort of the way it is right now, and employees are frustrated too. I think the most important thing everybody wants to know is that we all care about everybody, and we want everybody to be safe. And this is like the time to go back to just basic principles of, as frustrated as I am today, there is no reason that my assistant needs to see my frustration. She didn't cause it. And if, as much as you can emphasize that to your supervisors and your managers of, this is the time to be compassionate. And I tell you this for this reason. Employees don't know that you had a bad day. They don't know that you're frustrated. They don't know that you had a hard time with virtual school. So when they see, when they have a bad interaction, or that their manager's in a bad mood, they internalize it and they think that that person's mad at them. and they immediately think it's for whatever protected category or some protected issue that they brought up. Leaving all of our personal issues at the threshold is the best way we limit liability. And if you can take that message back to your management team, that's the best advice I can give you right now, is this is our time to be compassionate, because this is tough for everybody. Provide as much safety equipment as possible. There has been all sorts of dialogue about masks or not masks. We know in North Carolina we're supposed to wear masks. Masks are not PPE. Regardless, if you can provide as much as possible to your employees, including masks, it's going to be up to them to wash them and dispose of them properly. But I really advise you to do that. Just those little things really make a difference. It just shows you care. It's expensive. We're all cutting corners, but to the extent that you can say, we care about your safety, and here's this mask, and everybody wear it when you're not in your, except in your own little office, or if everybody works together, everybody needs to wear it. There's some folks who don't like masks. If you can, for legitimate breathing problems, look into face shields, something. I really advise you to do that. Our General Assembly has looked, and with the governor, passed legislation that will be in effect for a limited period of time. This law was passed just this month, and it provides liability limitation to companies related to COVID-19. And I'm not sure how much this has been publicized, but it is important. It limits liability for COVID-19 related claims except for gross negligence, willful and wanton intentional torts. And this doesn't apply to workers' comp claims. So let me and I want to add one more thing. It's going to expire 180 days, so basically 6 months after the governor lifts what is in effect the state of emergency executive order that was first entered in March 10th. So what's happened is March 10th, the governor entered that state of emergency order, and he's just been rolling it on and on and on whenever he updates it and changes it one way or the other. So whenever that state of emergency is finally lifted, then this statute will expire 6 months after that. So, and how this is going to work is that, say you're a business owner and you have customers who come onto your site for whatever purpose. This is going to limit you from liability unless, let me give a horrible example. You go up and intentionally cough in somebody's face or something. That's what this is intended to do. There are some requirements for you to do. You need to post on your premises precautions you're taking. So for instance, you need to be putting those little, social distancing, stay 6 feet apart in the checkout line, or put something on your door that says you cannot come in unless if you have any COVID related symptoms, or if you have a temperature, if you've been exposed. You need to have a requirement for folks to wear masks. You need to have those basic requirements that at the particular time that match whatever our state or our local officials' requirements are. It's not going to immediately say you're responsible if you don't do that, but that's what the statute's requirements are. And so the intention is that if businesses do what they're follow all the advice that we get from CDC, that we get from our, Dr. Cohen at the Department of Health and Human Services, that they shouldn't be held responsible if somebody gets sick, because frankly, we don't really know how people get sick anyway. We just don't know. Now, the reason it doesn't apply to workers' comp is because workers' comp is a no-fault statute anyway. And that process is just going to be its own process. The insurance carriers are going to do their own thing about saying whether someone got sick at work. All those same defenses are going to apply. So that's why this doesn't cover workers' comp. It wasn't meant to alter the workers' comp statute, but it will affect it. It's going to be a shield from those third-party claims. It would also be, for instance, a shield from a family member of an employee who tries to make a claim that says this employee got sick at work and now I'm going to try to sue the employer. So this is huge for North Carolina. Our legislature and our governor has done a great thing for businesses. I truly don't think there's been enough discussion about this, but this is really going to allow business to operate safely without having to have a constant look over the shoulder to see if they're going to be sued. So, Holly, did we have another poll? I cannot remember. That may have been our last one. Okay, we did have one. Yeah. So just kind of seeing where folks are. Did your company have layoffs or furloughs due to COVID-19? Were they temporary and everyone's back? Temporary and everyone's not back? Did you have permanent layoffs or no furloughs or layoffs?
I'll give you guys about 10 more seconds to vote.
This is a really fortunate group. So we had some temporary furloughs and everyone is back. So that's great news. And then most folks didn't have furloughs or layoffs. So we have a very fortunate group here. So that's great. It's really great. So hopefully this is a good signal that the folks attending today have found ways to work remotely, get business back, and hopefully working back on site. Are there any other questions?
While you guys are typing in your questions, I also want to direct your attention to the chat window. We've posted some of the links to documents and resources that were in our PowerPoint there, so you can hold those for review. We'll also put those up on our website later, Beth, if that's okay with you.
Oh, that would be great.
Post a replay of this.
That would be great. And if any of you have follow-up questions later, I'll be glad, feel free to reach out to me directly. I'll be glad to answer them. And thank you all so much. You've been such a great group. I really appreciate this opportunity to spend some time with you. These are very interesting times. Just the fact that you wanted to get more information just shows how much you're trying to be prepared. So thanks so much. I appreciate everything.
So I have a question. I have an employee who refuses to return to work, but does not have COVID-19 symptoms and is not high risk. They just say it's unsafe to return. What should I do?
So if your workplace has all returned to work and you've made the decision and the determination that this position needs to be back on site, you can do a couple things. You could decide that you you want to give this person a little more space up until, say, X date, you know, say until, if you want to work remotely until we go to phase 3, or you can just let the individual know that, you know, you're on, you know, you don't have any more remote work available, and you can decide to part with them. But I would stress that you need to kind of carefully look at any risk you have associated with that individual. Are they in any protected category or something like that? And you may want to kind of walk that scenario through with your legal counsel before you make an ultimate decision to terminate.
Beth, I don't see any other questions at this time.
Okay. Well, thank you again. Good luck, everybody.
Beth, thank you so much for being here today. I appreciate you coming and sharing such good information with our group. To our audience, thank you for being here as well. I hope this seminar has been valuable to you. Again, we will post some information and the replay on our website at mygma.org under the Member News and Resource section. We also have webinars coming up every Tuesday in August, so check out our schedule online and see what interests you, and we'll hope to see you there as well. Thank you again.
Thank you, Holly. Thanks, everyone.